Today on Legalese, we will be analyzing the oral arguments in the bump stock case that came before the court last week of Garland v. Cargill. Hey, greetings everybody, and welcome back once again to Legalese. Now, as always, I am your host, Bob, and I want to thank you all so much for joining me here today. If you happen to be new to my channel, let me bid a special welcome to you. This is the podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, just real quick, I want to remind you guys that if you want to find out more about the show, you can go check out our homepage over at legalespodcast.com. And if you want to stay up to date whenever I post any new content, because I don't just do videos on YouTube, I post to alternative platforms like Rumble and Odyssey. There's an audio-only version on Spotify. I also write a lot of articles over on Substack. And to get notifications for all of that stuff, all you have to do is go subscribe to our newsletter by heading over to legaleseshow.com. All right, well, fuck, we have got a lot to get to today, so why don't we just jump the fuck right in? So today on Legalese, we are going to be discussing the recent round of oral arguments that were heard before the court in the case of Garland versus Cargill. Now, this is the case in which the court is being asked to decide whether a bump stock is a machine gun. Now, this is a fascinating case that I have actually been following personally and here on the show since it first came before the district court back in 2020. Now, when the case started, it was actually known as Cargill v. Barr, but we have also talked about this case several times on several shows, including an episode that I made last January of 2023 when the Fifth Circuit Court of Appeals would issue their opinion, and this is the lower court case the Supreme Court is reviewing. And we discussed this case again back around November of 2023 when the Supreme Court would grant cert, and I added this case to my annual Supreme Court roundup. Now, this case involves whether a bump stock is a machine gun under the Gun Control Act and the National Firearms Act. Now, to help me define what a bump stock is, I figured I would turn to CNN, who are, after all, the most trusted name in news.
These bump stocks said that they did not have the power, at least in their kind of lawyer's opinion, to regulate these items. Is what the NRA is saying. The ATF needs to go back and reconsider, and that, I'm told, is the preferred route for Republican leadership that is very wary of a lengthy, kind of toxic gun debate. It's not on their agenda, and very concerned about what that might mean going forward. But it's worth noting, Senator Dianne Feinstein, Democrat in the Senate, who is introducing a bill to ban bump stocks, says that's not enough.
Now, as you can see here, from this very impressive animation that they created, they show that a bump stock is a gun that has a silencer and a grenade launcher and no bump stock. You see, actually, what this animation here is showing is a collapsible stock, which is not at all the same thing, and it is quite impossible to bump fire a weapon with this kind of stock. Now, really, this is why I try to take every opportunity I can to point out how gun control advocates really are their own worst enemy. And this is a point that I have made here countless times over many years on this show. And I'm not saying this to be insulting. I'm sorry, it's just a fact. So the gun control movement consists of a very select few people at the top who willfully lie with every single claim that they make, while the vast majority of gun control advocates are good, decent people who have the very laudable goal of wanting to save lives, and who I know genuinely believe that gun control is the answer because that is what news networks like CNN and people like Mike Bloomberg have been willfully and maliciously lying to them about for years.
So let's just look at the assault weapons ban.
Yep.
We had one in this country for 10 years. Every single weapon used by the shooter in Connecticut would have been okay under the old assault weapons law. They were all exceptions.
Yeah, okay, so the law is flawed. Fix it.
Isn't it pretty hard to define what is an assault weapon? Because it's so easy to write around for manufacturers to create weapons that...
Well, if it can fire a lot of bullets very quickly, that's a good place to start. Let's get serious here.
But that would ban most pistols. That would ban most...
No, but pistols are different. You have to pull the trigger each time. An assault weapon, you basically hold it, goes... Blah, blah, blah.
Listen, I told you one time. I'm gonna tell you 2 times. You lie to me once, I'm gonna put your ass through a mother wall. You lie to me twice, I'm gonna start screaming. I'm gonna start screaming on that ass. I'll be like, oh! That'll be the last thing you ever hear, bitch.
The position that a lot of people are going to say is all you're going to accomplish is taking guns away from the good people and the bad people are still going to
No, that's not true. The statistics say that if you have a gun at home, you are 22 times as likely to shoot a family member or a friend as to somebody breaking in. Don't try to go for a gun. You've got somebody pointing a gun at you. You think you're going to be able to outshoot them? That's one of the stupidest things I've ever heard.
Oh! Oh! Oh!
And look, I realize I'm getting pretty off topic here, which I don't like to do in my Supreme Court videos, but I really would be remiss if I didn't invite anyone watching this video who is in favor of gun control to go check out my past videos that really empirically disprove the willful lies coming from those few at the top of your movement. So I will include a playlist of such videos on the show notes page for this episode. And if you are a gun control advocate, I would ask you, please, I humbly ask you, just go take the time to watch them. And I won't even ask you to take my word on these issues. Just watch my videos with a highly skeptical frame of mind that doubts every single claim that I make if you wish, but then just go and independently verify the information in them for yourselves, because I promise it all checks out. And look, even if after all of that, I don't change your mind about the great harm of gun control, you will still come out the other side a more knowledgeable person, which will only make you a better advocate for your cause. You really have nothing to lose here. But let's get back to the matter at hand. So, when we talk about what bump stocks actually are, now these are devices that basically harness the recoil energy of a gun to quickly reset the trigger of a semi-automatic firearm. And what they do is they allow an individual who is shooting a semi-automatic firearm to replicate the rates of fire of a true full automatic weapon, which, I must add, is incredibly easy to do even without any kind of assistive device like a bump stock. The fact is that bump firing is something anyone with a semi-automatic rifle can do. And to demonstrate this, I want to play you a video with a retired ATF agent and a reporter from Vice News who both attempt to bump fire a gun without any assistive device for the very first time, and you see them both figure it out in like 10 fucking seconds.
Have people discovered a way to bump fire without a device, without a bump stock?
Guys figured out that if you held a gun loosely and practiced with it, you could get the gun to recoil against your finger. I've never done it. I can attempt to do it now and see what happens.
I mean, we should try, right?
We can try. There it goes. Would you like to try it?
Sure, I'll shoot. Yeah.
Like 4. Now you're doing burst.
Yeah, I mean, it feels like a machine gun.
But it's not.
Yeah.
I mean, this is clearly a semi-automatic firearm.
Yeah.
All right, go shoot it till it's empty.
If Congress banned the bump stock, would people just find another way?
Now, I want to be clear that I am pointing this out here actually for a very good and applicable reason. Because one thing that Brian Fletcher, who is the attorney representing the federal government in the case of Garland v. Cargill, tries to claim over and over is that an unassisted bump fire may be theoretically possible, but it takes some sort of master trick shooter who spends years practicing unassisted bump firing if he ever even wants to have a chance of ever possibly getting it to work properly. And I want to show you that that is just complete bullshit. People can do it in like 30 fucking seconds. However, of course, in this case, the question here before the court is whether this device qualifies as a machine gun under federal law. And on this issue, the circuit courts were enormously split, which is what has brought this case before the Supreme Court. Now, some judges thought that these bump stocks clearly qualified under the statute as a machine gun because individuals had only to, as they saw it, pull the trigger once and then the gun did the rest to fire off multiple rounds. Now, other judges thought that the trigger reset that happens every time you shoot made them clearly not machine guns. And then there were other judges still who fell right in the middle and thought that this law was ambiguous. And in fact, this last option, that the statute was ambiguous as applied to these devices, set off an entirely different second sort of jurisprudential split, with some judges saying that the ATF determination that bump stocks were machine guns were entitled to Chevron deference. While at the same time, other judges were saying no, this is a criminal statute, and therefore the rule of lenity applies. And it is these important and difficult questions that, to me, make this case not only a case of great importance, but also exceptionally fascinating on a legal level as well. Because this case comes at the intersection of administrative law and criminal law in a fairly unique way. Now, all the definitions in the National Firearms Acts of different kinds of restricted weapons all pose very interesting questions of their own. However, this is actually only the second civil case the Supreme Court has ever taken about those definitions. Now, the first case was in 1992. It was called United States versus Thompson's Center Arms. And that case had to do with whether a combination of parts that were intended to be assembled as a pistol or a rifle with a long barrel was actually a short-barreled rifle because it could be assembled in that way. And the Supreme Court would hold 5-4 that the statute was ambiguous and therefore the rule of lenity applied. And that was the finding of the plurality in the opinion issued by Justice Souter. So, just to remind people, I know we've talked about this before, but when it comes to the rule of lenity, I want to refresh you guys' memory. The rule of lenity is a principle used in criminal law, also called a rule of strict construction, which states that when a law is unclear or ambiguous, the court should apply it in a way that is most favorable to the defendant or to construe the statute against the state. Now, the rule of lenity stems from two constitutional objectives. First is the separation of powers, as it limits the scope of statutory language in penal statutes and does not allow the courts to establish the contours of a crime and its punishment. Second, the rule of lenity stems from the wish to protect the legislature's constitutional lawmaking prerogative and limit the court's encroachment on the legislative function. Now, a concurring opinion would be filed in that 1992 Thompson case by Justice Scalia, which was joined by Justice Thomas. And the Souter opinion was a three-judge opinion, and it was this additional concurring two-judge opinion on top of the plurality that gave the case its final 5-4 vote. Now, what Scalia and Thomas said was that actually this statute was clear and you don't need to resort to the rule of lenity, but if it was unclear, they certainly agree that the rule of lenity would apply. And they also make another very interesting point about the civil and criminal distinction that I think most people don't even think about when they think about the rule of lenity. So they pointed to actually a dissenting opinion by Justice Stevens, and they said Justice Stevens further suggests that lenity is inappropriate because we construed the statute today in a civil setting rather than as a criminal prosecution. But the rule of lenity, however, they point out, is a rule of statutory construction, whose purpose is to help give authoritative meaning to statutory language. It's not a rule of an administration calling for courts to refrain in criminal cases from applying statutory language that would have been held to apply if challenged in civil litigation. Now, the rule of lenity goes way back in history, and we can find William Blackstone in his great commentaries on the common laws of England, where he talks about the fact that the criminal statutes have to be construed strictly. So he says if there was an ambiguity in a criminal statute, you interpret it against the government in favor of the citizen. Or, and I actually like this phrasing of it much better, what Justice Gorsuch likes to say, you interpret it against the government in favor of liberty. Now, the reason I want to bring this up, this whole rule of lenity issue, is because actually, in fact, in the Garland v. Cargill case, uh, what caught my attention when listening to the oral arguments is that the rule of lenity wasn't ever mentioned once. And essentially, both sides were trying to convince the court that the statute is crystal clear. Both sides came to the court with the argument that the other side doesn't have a case and that there's no ambiguity and therefore there's no need to even refer to lenity. Though I point this out because I actually do think, however this case shakes out, that lenity will end up being a factor in the final opinion of the court. Now, the other strange thing that happened with this case is that if you go back to the period actually of rulemaking on this matter, the ATF initially claimed that it was entitled to Chevron deference. However, the government has since dropped that argument, and they actually dropped it fairly early on in the litigation, likely for several different reasons. First is because the ATF has consistently said in the past many, 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 many times that bump stocks are categorically not machine guns. It was really only after the Las Vegas tragedy that the Trump administration, which I just have to say is possibly the most anti gun administration of my lifetime, told the Justice Department to adopt a rule basically saying bump stocks are machine guns. And if you're asking why they said that, the best answer I can come up with is because they seem to think, as if by magic, the ATF ferry can use completely external and unconnected circumstances like the Las Vegas shooting to actually change the physical nature of a device. So, what the ATF did in this litigation was to say that what we're talking about here is an interpretive rule and not a legislative rule. And this is a big, important difference because the difference between an interpretive rule and a legislative rule is that interpretive rules do not bind the public, nor do they have the force and effect of law. It's merely a statement made by an administrative agency about how it interprets a given law or regulation. So, with an interpretive rule like this, it just tells you what the agency is saying about how they interpret the statute. On the other hand, if it's a legislative rule, this is considered to be binding, and in that case, Chevron deference would apply. Now, of course, the other reason the ATF has likely changed their tune on Chevron deference, as viewers of this channel will be very well aware, is that Chevron deference may not exist for much longer. Now, this is, of course, the doctrine that says that in a case where a statute is ambiguous in administrative law, that the court should defer to an agency interpretation of the statute as long as that definition is reasonable. However, in the very recent Loper Bright and Relentless cases, which we've been covering here extensively on this channel, and I'll link to those videos in the show notes page if you want to check up on those as well. But it's become very apparent that the opinion of the court is going to almost certainly be to overturn Chevron versus National Resource Defense Council, which would thus overturn Chevron deference itself for good. So now getting to the actual case here at hand, Garland v. Cargill, let's start by just a quick refresher about what exactly is the question presented before the court. So the QP asks whether a bump stock is a machine gun as defined in 26 USC section 5845B because it is designed and intended for use in converting a rifle into a machine gun, i.e., into a weapon that fires, quote, automatically more than one shot by a single function of the trigger, end quote. Now, as we mentioned earlier, while the circuit courts overall have been very split on this rule, the particular lower court decision that the court has chose to grant review on in this case is a decision that came out of the Fifth Circuit. And in that particular case, the holding of the Fifth Circuit was as follows: that the definition of machine gun as set forth in the National Firearms Act and Gun Control Act do not apply to bump stocks. And if there were any doubt as to this conclusion, we conclude that the statutory definition is ambiguous at the very least, and the rule of lenity, therefore, would compel us to construe the statute in Cargill's favor. Either way, we must reverse. Now, again, I mentioned this, but the ban on bump stocks that the court is considering in this case, Garland v. Cargill, came in the wake of the 2017 mass shooting at a music festival in Las Vegas. And it is believed that this shooting might have been carried out, at least in part, by a semi automatic rifle fitted with a bump stock. And so the Supreme Court heard oral arguments last Wednesday, and it was very clear that the justices here were divided over the validity of this 2018 federal regulation that bans bump stocks as a rifle attachment. Now, the Trump administration, the most anti gun administration of my lifetime, forced through this regulation that barred ownership of bump stocks, which transforms a semi automatic rifle into a weapon that can discharge at a rate of fire similar to machine guns and is therefore a machine gun under the existing general prohibition thereof. Now, although some of the court's conservative justices did express concerns that the regulation could subject the owners of bump stocks to criminal liability, even though the devices were legal when they purchased them. Several justices also contended that the lethal capacity of the semi-automatic rifle fitted with bump stocks was precisely the kind of weapon that Congress intended to target. This was the main split that we saw between the court. Now, a firearm with a manual action, and that would include any sort of a semi-automatic firearm, be it a rifle or a pistol, it will require the shooter to eject an empty cartridge after firing and load a new one before firing again. While a semi-automatic firearm automatically loads a new cartridge after firing, the shooter must pull the trigger each time he wants to fire a shot. And a machine gun, by contrast, will automatically reload new ammunition and continue to fire as long as the shooter keeps his finger on the trigger. Now, until 2018, the Bureau of Alcohol, Tobacco, Firearms, and Explosives had indicated that only certain kinds of bump stocks transform semi-automatic rifles into machine guns. And this was a question that they had been asked to review many, many times in the past by administrations, both Republican and Democrat. And in the past, they've always found that these bump stocks either categorically don't apply or perhaps specific types do apply, but not the vast majority. But this would all change in the wake of the 2017 mass shooting at a music festival in Las Vegas, in which a single shooter would kill 60 people and injure 500 more. The ATF issued a rule concluding that bump stocks are machine guns, and under the 2018 rule, anyone who owned or possessed a bump stock was required to either destroy them or turn them over to the ATF to avoid criminal penalties. Now, the respondent in this case, Michael Cargill, is the owner of a Texas gun store, and when this ruling came down, he surrendered his bump stocks, but he also went to federal court seeking to have the rule thrown out. Now, the U.S. Court of Appeals for the Fifth Circuit would indeed agree with Cargill that the federal law defining machine gun does not apply to bump stocks because semi-automatic rifles equipped with bump stocks do not shoot multiple bullets automatically or by a single function of the trigger, which is what the law requires. But in any event, the Court of Appeals also held that the rule of lenity would apply to an ambiguous criminal law in a way that is most favorable to the defendants. And though they didn't feel that this law was ambiguous, even if you went with the government's argument that it was in that case, this would also weigh in favor of excluding a bump stock from the definition of a machine gun. And it was the Biden administration that came to the Supreme Court, which agreed to hear this case last year. And at Wednesday's oral arguments, the justices would spend substantial amounts of time delving into the highly technical mechanics of firearms. Now, Justice Clarence Thomas, for example, would press Deputy U.S. Solicitor General Brian Fletcher, who was representing the Biden administration, on how a semi-automatic rifle equipped with a bump stock operates differently from a machine gun. Now, Fletcher emphasized that to fire a machine gun such as an M16, which is an automatic rifle commonly used by the U.S. military, a shooter would press the trigger back and hold it. To fire a rifle equipped with a bump stock, he explained, the shooter would push the rifle forward, which both initiates the continuous fire that is, as in their opinion, a single function of the trigger, in line with the wording of the statute at hand. And Fletcher contended that because the shooter only takes one action, pushing the rifle forward, that is why this is a single function of the trigger.
Welcome the court's questions. Mr. Fletcher, how does a machine gun, what would I have to do to fire a machine gun?
It depends on the machine gun. Some it's a push of a button. Some it's a pull of a trigger. The statutory definition is, does it shoot more than one shot automatically by a single function of the trigger?
But I don't have to do anything else. I don't have to put pressure on it or anything else.
It depends on the gun, again. So if you imagine, I think what your question is getting at is if you take a traditional M16 rifle, what we often think of when we think of a machine gun, you're right. To fire more than one shot, you pull the trigger and you have to hold it back, and as long as you maintain that backward pressure on the trigger, it keeps shooting.
With a bump stock, what would I do different?
You would do different, both the initial motion and the motion that continues. It's the same thing in the sense that one motion automates back and forth movement and results in multiple shots.
So what is happening with a trigger initiated firing of a machine gun? What do I have to do other than to press the trigger?
With a traditional machine gun, again, take an M16, and again, we think they're all machine guns, but I understand the question to be, take an M16, you pull the trigger back and you hold it and it keeps shooting.
Okay.
With a bump stock, you push forward and that both initiates and continues the firing.
And what is happening with the trigger when you have the recoil?
That's exactly right. So I think this gets to respondents' primary argument on function of the trigger, which is that the difference with a bump stock is that it fires multiple shots automatically by automating the movement of the trigger. So my friend says the trigger moves back and forth every time a shot is fired. Our view is that those subsequent movements of the trigger aren't functions of the trigger because they're not responding to separate acts, separate pulls, or anything else by the shooter. They're just the result of the
So what is happening with the trigger when someone doesn't need a bump stock to bump fire a weapon?
So this is the unassisted manual bump firing that's described, where an expert can take a regular semi-automatic rifle and hold it loosely enough that they can do something like bump firing. And I think in our view there too, there's just one function of the trigger because the first push starts the sequence and then the sequence continues. The ATF explained, and we agree, that that's not automatic because there's no self-regulating mechanism. The user has to control
So what's the difference? The same thing is happening with the trigger.
The same thing is happening with the trigger, and I think that's why we would say with manual bump firing, there is just a single function of the trigger. There's one action that initiates the firing sequence. We think it's not automatic because there's no self-regulating mechanism. The user is having to do all of the work that the bump stock automates for you on a rifle fitted with a bump stock.
And representing Michael Cargill was attorney Jonathan Mitchell, and he would counter that, unlike a machine gun, a rifle equipped with a bump stock can only fire one shot per function of the trigger because the trigger, which initiates the firing of the gun, has to reset with every shot, and a function of the trigger does not occur automatically. And he insisted this is because the shooter must continually and repeatedly thrust the force stock of the rifle forward with his non-shooting hand while simultaneously maintaining backward pressure on the weapon with his shooting hand.
Mr. Mitchell?
Mr. Chief Justice, and may it please the Court. The statutory definition of machine gun extends only to weapons that fire more than one shot automatically by a single function of the trigger. Mr. Cargill's non-mechanical bump stocks fall outside the statutory definition for two separate and independent reasons. First, a bump stock-equipped rifle can fire only one shot per function of the trigger because the trigger must reset after every shot and must function again before another shot can be fired. The trigger is the device that initiates the firing of the weapon, and the function of the trigger is what that triggering device must do to cause the weapon to fire. The phrase function of the trigger can refer only to the trigger's function. It has nothing to do with the shooter or what the shooter does to the trigger, because the shooter does not have a function. The statute is concerned only with what the trigger does and whether a single function of that trigger produces more than one shot. Second, a bump stock-equipped rifle does not and cannot fire more than one shot automatically by a single function of the trigger, because the shooter, in addition to causing the trigger to function, must also undertake additional manual actions to ensure a successful round of bump firing. Everything about the bump firing process is manual, and there is no automating device such as a spring or a motor in any of Mr. Cargill's non-mechanical bump stocks. The process depends entirely on human effort and exertion, as the shooter must continually and repeatedly thrust the forestock of the rifle forward with his non-shooting hand while simultaneously maintaining backward pressure on the weapon with his shooting hand. None of these acts are automated, and the Solicitor General has yet to identify any component of Mr. Cargill's devices that automatically performs any task that is necessary for bump firing. The statute is unambiguous as applied to Mr. Cargill's non-mechanical bump stocks, and we ask the Court to affirm on that ground.
Now, Chief Justice John Roberts would go on to press Mitchell on exactly what action it is that the shooter takes. And although Mitchell, as Roberts observed, characterized the shooter as thrusting the rifle forward with his non-shooting hand, Fletcher described it in terms of maintaining pressure.
So you've said several times that you thrust with your non-trigger hand, thrust part of the gun forward. Right. And I understood your friend on the other side to focus on it more as maintaining pressure.
Right.
Which is it? I mean, do you hold it? You have to hold it harder at certain points rather than others, or are you actually moving it with the thrusting?
You're definitely moving your hand back and forth, and Mr. Fletcher agreed with us on that point. The hand is moving. I think where our disagreement comes in is that Mr. Fletcher seems to characterize the action of the non-shooting hand, so the left hand for a right-handed shooter, as something where you are applying constant pressure in a certain direction, but the recoil is strong enough to overcome that pressure from the non-shooting hand and thereby move the weapon backward despite the forward pressure that's coming from the non-shooting hand.
Now, at this point, I just want to point out that on the show notes page for this episode, you will be able to find a ton of links to videos that I have found that show you how a machine gun fires, how a bump stock fires, how a semi-automatic fires, and it really very comprehensively covers how all of these different types of firearms function and work, and they are all very good videos that actually show you what they are talking about, and you can see besides just hearing the technical answer. And anyone who is in any way unfamiliar with a bump stock, I would highly recommend you go and you check out those videos for yourself. But moving on, Justice Elena Kagan would at this point intervene and suggest that the shooter doesn't actually, quote, make sure that the hand is moving back and forth, but instead just make sure that he is pushing forward, end quote. Now, Mitchell conceded that Kagan was probably right, but stressed that even if the shooter is simply applying a constant pressure with the same amount of force, he is still acting manually rather than automatically, as the statute requires.
That means that tell me if I'm wrong, but that means that the way a shooter perceives it is by imposing constant forward pressure. Not the shooter is thinking, I got to do this really fast, going back and forth.
The shooter can do both, and it takes a lot of practice to master the art of bump firing. So there is always going to be recoil energy, and no person, I think, is strong enough to push forward in a way that overcomes the recoil energy. If they were, bump firing wouldn't happen. So for successful bump firing to occur, there needs to be that back and forth motion. There's recoil every time the rifle fires. There's still pressure from the left hand or the right hand if you're a left-handed shooter. There's still going to be pressure from that non-shooting hand. But the shooter can decide how much he wants to calibrate that pressure in response to the repeated recoils that he's getting from the bump firing. It doesn't have to be the same amount of pressure each time. The shooter just has to make sure that the hand is moving back and forth, because that's the only way you can have successful bump firing. But to get back to your question, Mr. Chief Justice.
But the shooter doesn't make sure that the hand is moving back and forth. That's the way the recoil operates. The shooter just makes sure that he's pushing forward, and then the recoil operates to, in fact, even though the shooter is not experiencing this, is not volitionally experiencing this, the shooter is not moving his hand back and forward.
That's probably right, unless the shooter is so strong that he has to ease off a little bit to make sure he doesn't overcome the recoil. But to my knowledge, I don't think there's anybody strong enough to actually be able to keep pushing and forcing it past the recoil energy. But, Mr. Chief Justice, I don't think the answer to this question matters in the end. Because even if we accept Mr. Fletcher's characterization, where it's just constant pressure with the same amount of force continuously over a sustained period of time, it's still a manual action. There's nothing automatic about that. The shooter is the one who is pushing. It's human effort, human exertion, nothing automatic at all about this process. And Mr. Fletcher said during his remarks that the bump stock harnesses the recoil energy of the weapon. That is false.
Now, of course, the justices also move past these very small technical issues and focus on the broader and less technical issues with this case, such as the effect that the 2018 rule could have on bump stock owners who purchased the device when they were legal. And Justice Neil Gorsuch was the first to flag this concern. He told Fletcher, the attorney for the federal government, that he could, quote, certainly understand why these items should be made illegal, end quote. But he would observe that before 2018, the ATF had repeatedly indicated that bump stocks are not machine guns, and as a result, the agency's about face in 2018, Gorsuch complained, somewhere between 250,000 and 500,000 people could be convicted of felonies overnight, which could lead not only to jail time, but also the loss of other civil rights, and not just the right to own a firearm, but even the right to vote. Now, Fletcher would push back here, responding that in the wake of the Las Vegas shooting, it, quote, would have been irresponsible for the ATF not to revisit its earlier interpretation of that definition of a machine gun and to revise it if concluded that it was incorrect, end quote.
Fletcher, on that score, can we just step back a minute? I can certainly understand why these items should be made illegal. But we're dealing with a statute that was enacted in the 1930s. And through many administrations, the government took the position that these bump stocks are not machine guns. And then you adopted an interpretive rule, not even a legislative rule, saying otherwise, that would render between 250,000 and 500,000 people federal felons, and not even through an APA process they could challenge, subject to 10 years in federal prison. And the only way they can challenge it is if they're prosecuted. And they may well wind up dispossessed of guns, all guns in the future, as well as a lot of other civil rights, including the right to vote. Then why not do a legislative rule properly, and in which I know you did notice and comment, but it was an interpretive rule, and an interpretive rule you can more or less just issue. And you don't even have to put it in the Federal Register. I mean, maybe you do in some circumstances, but not all.
Well,
and you're creating a class of, again, between 250,000 and 500,000 people who have, in reliance on past administrations, Republican and Democrat, who said that this does not qualify under a very old statute, taken actions. And an interpretive rule, you can't even challenge in an APA posture.
Well, we are in an APA posture. They are challenging an interpretive rule.
Well, I understand that, but in your reply brief, you say, don't touch that, because that's not before us. That's not part of the QP. And in an interpretive rule, you don't get an APA challenge. You get a criminal prosecution against you is what you get.
So
Now, Justice Brett Kavanaugh would pick up on Gorsuch's line of questioning a few minutes later, and Kavanaugh would ask, could someone be convicted even if he wasn't aware that bump stocks are now prohibited? And when Fletcher's answer to this question was yes, Kavanaugh would shot back essentially, quote, that's going to ensnare a lot of people, end quote.
Can I ask you about mens rea, to pick up on Justice Gorsuch's questions, for prosecuting someone now? What mens rea showing would the government have to make to convict someone?
So I think the relevant case is Staples, and I think what the court held in Staples is that you have to be aware of the facts that render your weapon.
So even if you are not aware of the legal prohibition, you can be convicted?
That's right. But that's true of all machine guns. I mean, all different sorts of devices. I think the distinct problem here is the one that's created by the fact that the agency was previously saying that these were not machine guns. We acknowledge that those people who, in reliance on that.
That's going to ensnare a lot of people who are not aware of the legal prohibition.
So I guess I don't think so, Justice Kavanaugh. I think the ATF, one of the reasons, to Justice Gorsuch's point, this is an interpretive rule that went through notice and comment. The reason was in part because the agency knew that it had previously been saying something different. It wanted to maximize public notice. This is something that's gotten a lot of attention.
Why not require the government to also prove that the person knew that what they were doing was wrongful, was illegal?
Yeah, well,
And in response to Fletcher's answer here, Justice Gorsuch would also follow up a few moments later with a devastating quip about the inadequacy of the government's arguments on this matter to turning erstwhile lawful gun owners into felons overnight.
The problem here, we acknowledge, is ATF used to say something different about these, but we think that's taken care of by the rulemaking and the doctrine of entrapment by itself.
Because people will sit down and read the Federal Register.
No, I think because people who have these devices.
That's what they do in their evening for fun. Gun owners across the country crack it open next to the fire and the dog.
I take that point. I think.
And similarly, Justice Samuel Alito worried out loud about bump stock owners who had the device between the 2018 rule and the decision by the Fifth Circuit holding that that rule is invalid. And Alito would characterize Fletcher's response to this question that they too could be held criminally liable as, quote, disturbing.
Justice Alito? What is the situation of people who have possessed bump stocks between the time of the ATF's new rule and the present day, or between the time of the new rule and the Fifth Circuit decision? Can they be prosecuted?
I think probably yes, unless they had gotten some judicial relief from the rule. The rule has not been enjoined. It hasn't been vacated writ large. So I think the government has made clear that this is what we think the statute means. I'll say in practice.
Isn't that disturbing? People in the Fifth Circuit who've been possessing firearms since the beginning of 2023, let's say they are aware of the Fifth Circuit's decision that they can be criminally prosecuted for doing something that the Court of Appeals that governs their territory has said is not illegal?
Well, let me give it.
But, of course, if some justices were concerned about bump stock owners, several other justices suggested that with the ability for these particular devices to fire at a rate of hundreds of rounds per minute, semi-automatic rifles equipped with bump stocks were precisely the kinds of weapons that Congress intended to capture within their definition of machine gun. Now, Clarence Thomas, for example, noted that the ban on most machine guns was originally enacted during Prohibition in response to, quote, significant damage from machine guns, carnage, people dying, etc., end quote. That the government, he told Jonathan Mitchell, is arguing that, quote, bump stocks do the exact same thing. So with that background, why shouldn't we look at a broader definition of what it means for something to be a single function of the trigger, end quote. And Justice Ketanji Brown Jackson would similarly posit that the category of firearms prohibited by the ban on machine guns was based, quote, on the high rate of fire, as opposed to the movement of the trigger, end quote. She would go on to say to Mitchell, who was the attorney for Cargill, that if you are correct, quote, why would Congress want to prohibit certain things based on whether the trigger is moving, as opposed to certain things that can achieve this lethal kind of spray of bullets, end quote.
So if the court is going to interpret the statute based on what it says, rather than based on the purposes or perhaps the overarching goals of what the 1934 legislature might have been, there's no way it could accept the government's construction of the statute because it is changing the enacted words.
Can I give you a way? possibly?
Please.
All right, so the statute says function, as we've all identified.
Yes.
And as far as I can tell, the sort of common usage of the word function is not its operational design. It's not the mechanics of the thing. It is what it achieves, what it's being used for. So I found definitions. Function is defined as the action for which a person or thing is specifically fitted or used, the acts or operations expected of the person or thing. So if you take that definition, it seems to me that through its use of the word function, Congress was trying to capture a class of weapons in which a trigger is used once to achieve a certain result, which says in the statute automatic firing many times. And so weapons with bump stocks have triggers that function in the same way. Through a single, pull of the trigger or touch of the trigger, you achieve the same result of automatic fire of the weapon. So why is that inconsistent with grammar or the way the statute reads?
Well, the premise of Your Honor's question is not true. A single discharge of the trigger produces only one shot. It doesn't produce a round of automatic fire. The only way you get to repeated shots with a bump stock equipped rifle is for the shooter himself to continually undertake manual action by thrusting the forestock of the rifle forward with his non-shooting hand.
But that statute is classifying certain weapons for prohibition.
Right.
So for it to make sense, we have to understand why this category of weapons are ones that Congress wants to prohibit. And you're suggesting that Congress is prohibiting through this classification weapons in which we hold it backwards and automatic fire happens, but we push it forward and automatic fire happens. Congress says no.
There's no automatic fire. I'm sorry, Justice Jackson. There is no automatic fire.
Sorry, 800 bullet. The conversation with Justice Kagan suggested that through a bump stock you can achieve the same kinds of result in terms of the amounts of bullets that are being ejected.
That
is that
true.
correct?
It has a very high rate of fire, but it's not automatic.
Right. But what I'm suggesting is that the category of prohibition is about the high rate of fire as opposed to, the movement of the trigger. And if you're right that it's about the movement of the trigger, I'm just asking why. Why would Congress want to prohibit certain things based on whether the trigger is moving as opposed to certain things that can achieve this lethal kind of spray of bullets?
And perhaps I would say Justice Elena Kagan was the strongest proponent of this argument. Now, she acknowledged that courts should interpret statutes by reading them, which is an approach known as textualism. We've talked about that here on the show before. I'm a statutory textualist myself, but she told Mitchell, quote, textualism is not inconsistent with common sense, end quote. And common sense, she said, leads to the conclusion that the statute is intended to cover a weapon that fires a multitude of shots with a single human action, whether it's a continuous pressure on a conventional machine gun holding the trigger or a continuous pressure on one of these devices on the barrel. And she would say that she could not understand how anyone could think that those two things should be treated differently.
Mr. Mitchell, I'll tell you, I view myself as a good textualist. I think that that's the way we should think about statutes. It's by reading them. But, textualism is not inconsistent with common sense. Like at some point, you have to apply a little bit of common sense to the way you read a statute and understand that what this statute comprehends is a weapon that fires a multitude of shots with a single human action. Whether it's a continuous pressure on a conventional machine gun holding the trigger or a continuous pressure on one of these devices on the barrel. I can't understand how anybody could think that those two things should be treated differently.
Now, a decision in this case is expected by summer. Now, in my opinion, it seems very clear that we are going to see the court affirm the holding of the Fifth Circuit that said the definition of machine gun as set forth in the National Firearms Act and Gun Control Act does not apply to bump stocks. And my best guess would be that we are going to see this case end in a 6-3 vote along those traditional conservative and liberal lines. All right, well, that's really all I have for you guys today. Thank you so much for tuning in to Legalese. Now, if you would take a moment, please, and do all of those things that help to trigger Al Gore's rhythm, I would greatly appreciate it. If you liked it, hit the like button. If you disliked it, hit the dislike button, though I would strongly prefer you hit the like button. It's up to you, though. Don't forget to subscribe to the channel so you always get notifications whenever new videos come out, including follow-ups that I will be doing on this episode when that case comes out. Also, please take a minute and share the show on your social media. Share it with a friend. Send it to someone you know who you think would find this information interesting or useful. And if you would do that for me as well, I would be very, very grateful for that. And so all this left to do is sign out. So I have been Bob for Legalese, talking about the bump stock case, and of course, as always, Carthago delenda est.
Motherfucker, like Freddie Mercury. Motherfucker. I got a trunk full of amps, motherfucker. I got a trunk full